everyone. Welcome and thank you for being here. My name is Alyssa, and Staples is really excited to be partnering with Rocket Lawyer today for our webinar on a topic that is on a lot of small businesses' minds right now, specifically workplace policies as it relates to COVID-19. We know there's a lot of information out there. It's not necessarily so that's why we're really happy to be able to provide these types of educational resources to help our small business community, especially during this time. Also, thank you to everyone that submitted questions in advance. I think you'll find that today's program addresses a lot of the top concerns. Legal question on your mind, please go ahead and scan the QR code that you'll see on your screen. You can also refer to the link that went out on our Eventbrite page as well. You can submit questions at any point during the broadcast, and we'll do our best to get to as many as we can before our time together is up. So with that, I'll turn it over to Charley Moore. He's the founder and CEO of Rocket Lawyer. Charley, so great to have you with us today. Take it away.
It's great to be here with you, Alyssa, and the Staples team, and all of you out there who are operating small businesses in this uncertain time. We just want to let you know that Staples and Rocket Lawyer are here for you. You can really do more than might be readily apparent. I also want to say thanks for bearing with us. I'm here working from home like probably most of you are as well, and trying to have business, and Rocket Lawyer is really here to help. Derek, you're about to meet, is one of the many attorneys in our on-call network. Like many of those attorneys in the network, Derek is an expert in his field. He's donating some of his time, again, to be here to help. And we thank you for spending a few minutes with us. We hope it's informative, and we look forward to serving you in the future. Derek?
Thank you, Charlie. Everyone, good afternoon. It is a pleasure to be here, and I'm really looking forward to help teaching you and discussing with you the basics of COVID-19 employment law related matters for us small businesses. And I say us because, like you, I have a small business, and that being my law firm. And being an employment lawyer, it also gives me some experience, and it gives me some knowledge that I have to help explain these matters to you. And do know that there are a few new laws that we as small business owners have to know about, because if not, we can find ourselves in some really hot water. Additionally, knowing these laws will help our employees and help our businesses. So today we're going to talk about four things. So there's going to be four sections to this talk. The first, we're going to talk about this new act that came into play. That's called the Families First Coronavirus Response Act. Next, we're going to talk about workforce and workplace safety. Then we're going to talk about furlough and termination. And lastly, we're going to have some questions and answers with you. So going back to the Families First Coronavirus Response Act, there are two main parts of that. Now the essential part of the Response Act is that when your employees go on leave because of coronavirus, you're going to have to pay them under certain circumstances. So we need to know what those circumstances are. So in this Families First Response Act, we have two parts. We have the short-term leave and we have the long-term leave. So the short-term leave is called the Emergency Paid Sick Leave Act, known by this terrible acronym EPSLA. And then the long-term leave is the Emergency Family Medical Leave Expansion Act. So let's discuss the short-term leave first. and that would be on slide part 1A. And let's wait until we get to that so I can show you. And let me see if that's there. Good. Okay, so the Emergency Paid Sick Leave Act, now that was right, applies to small employers. Now, small employers are known as any employer that has less than 500 employees. And for both of these, it applies if you have less than 500 employees. If you have more than 500 employees, you are not covered. You don't have to pay. Don't ask me. Don't even question why it is that way, because I'm not sure, and I don't think it should be. But this only applies to employers that have less than 500 employees. So under the short-term leave, we're talking about 2 weeks of paid leave that you, the employer, have to pay your employees. They are covered regardless of how long they've worked for the company. You may have heard of the Family Medical Leave Act. You may have heard of other employee laws where they are entitled to certain benefits and you have to work for at least a year. This is the first time that I've ever seen that where an employee is working for just one single day, they are triggered and you would have to cover them under this leave, Emergency Paid Sick Leave Act. So in order for a person to be covered and in order for you to have to pay them for 2 weeks of paid leave, they have to be unable to work because of one of the following reasons. So let's go to the next slide, please. The first reason would be that they are subject to a quarantine order or advised by a healthcare provider to self-quarantine, or they are experiencing COVID-19 symptoms and are seeking a medical diagnosis. So I'm going to summarize the first reason. The first reason is summarized in that if there is a coronavirus issue with them, the employees themselves. So it's important to understand that the employee has to actually come to you and trigger this benefit. They have to say, I am unable to work because I've got symptoms or I'm seeking out a diagnosis with a healthcare provider or a healthcare provider has told me to stay home. That's themselves. And it's important to note because when it's by themselves, the coronavirus issue, they are entitled to up to $511 per day for up to 2 weeks or 80 hours. So that's the maximum amount that you're going to see in what we're discussing. So I want you to understand if the issue concerns them and it's for the first 2 weeks, they're due up to $511 per day. After that, let's talk about the other reasons. After that, we have if the person is not caring for themselves, but they're caring for someone else. They're caring for an individual who is subject to any coronavirus issue, subject to a quarantine, they're sick, what have you. If you noticed, I said an individual. It doesn't have to be a family member. It could be someone who they're expected to take care of. It could be a roommate. It could be a friend who has no one else to take care of them. In that case, if they're taking care of someone else, they're entitled to not $511, but they're entitled to $200 per day, up to 2 weeks, which would be 5 days, working days per week, which would be a total of $2,000. The last reason, we're going to skip the very last one because that doesn't really apply. The last reason is on the next page, caring for a child whose school or place of care is closed. I'm sure the slide is going to move shortly. The next page where it talks about caring for a child whose school is closed. Oh, there it is. So if the child, if their school is closed and they are home, and I want to clarify, when you hear the word closed, just because the kid is working at home virtually, and which is what I'm seeing most of the children are doing these days, the school is still technically closed for purposes of this act. So if your child is, or a child, notice the language there, caring for a child, if the child is home and you are caring for them, even though they're doing school and you cannot work because of it, you are obligated to pay that employee, again, $200 a day, up to $2,000. That is also measured at 2/3 of regular pay, up to that $200 per day. What happens after those 2 weeks? Well, after those 2 weeks, we go to the emergency FMLEA. So let's go back to the very first slide, 1A, 1B, that one, part 1, please. Where it talks about, thank you. So there, if you notice 1B says the Emergency Family and Medical Leave Expansion Act. So that kicks into play and will cover the employee for an additional 10 weeks. But the catch is the person has to be employed for at least 30 days with you. So unlike the emergency leave, where if they were employed for just 1 day with you, they're covered, this one is they have to be employed for at least 30 days in order to receive money. In the event they're there for at least 30 days, they will receive money that you have to pay them up to $200 per day for 10 weeks. But another catch is that the only reason, unlike the emergency one, which has all those other reasons, caring for yourself, caring for others, the only reason that applies here is if the the employee cannot work because they are caring for a child whose school or daycare is closed. And I want to briefly talk about that for a second. So let's say an employee has a 17-year-old child who's working from home. They're doing their classes. They can make lunch from themselves. They don't need care. That type of situation, they would not be entitled to recover any of this pay because they could still work. A very important part of what I'm explaining is that there must be work, number one, and number two, that the employee cannot do it. So that would apply to whether it be work on site for essential workers, let's say, or it would also apply for teleworking. So if an employee is able to telework, they would not be able to recover. This only applies when the employee is not able to work for one of these reasons. Also, please do yourself a favor and document everything. So if an employee gives you that quote unquote trigger by saying, look, I can't work because of one of these reasons, make sure they document it, or at least you document it in their file, the reasons given, why they can't work, etc. Don't give them a hard time, because if you give them a hard time, or worse, if you take any adverse employment action against them, such as firing them because they take the leave or ask for it, they can sue you for retaliation for interfering with their rights under this. So let's get to the good news and switch to part 1. It's page 11 on my slide, tax credits. Hold on one second, please. Okay, so the bad news is we're already under a crunch. We have coronavirus crisis going on. We're having problems making payroll as it is. Business is not what it used to be. And Derek, you're telling me that I have to pay these employees when they're not going to be working? What are you, nuts? How am I going to do this? Well, fortunately, the Act heard us, and the Act provides for 100% tax credit reimbursement to us, to you, the employers, small business owners, for anything that you pay here, which is why it's good to document it. And what that means in tax credit. So for those of you who don't fully know this, we have whenever you pay your taxes, your payroll to your employees, the employee has taxes taken out for the employee's taxes, but also the employer pays the employer's share of taxes. So that would be like FICA and FUTA, if you ever heard of that. The good news is you will not have to pay those payroll taxes until you get fully reimbursed for what you paid out to the employees. And even better, if the amount that you pay out exceeds, you will get a reimbursement check from the IRS. That would also cover tax credit for health insurance. Please make sure you continue to pay health insurance while they are out on leave if you already pay for their health insurance. Credit for the eligible employers. This act started April 1st and goes to December 31st, meaning that if your employees went out for any of these reasons before April 1st, you don't have to pay them. You're not responsible. Likewise, after December 31st, the program is over. So now I'd like to shift attention, and now let's talk briefly about workforce and workplace safety. So workforce and workplace safety, it's still, you still have an obligation under OSHA to provide a reasonably safe work environment for your employees. That should go without saying. But we have a few new wrinkles because of coronavirus and whatnot, and lots of questions that arise. And you as an employer, in order to help keep your safe environment, you're allowed to require that an employee submit to a medical exam to determine whether or not they are infected with COVID. So that seems kind of unusual to some, that you can say to an employee, I'm not letting you back in here until you get a medical exam showing whether or not you have COVID or showing that you don't have. So feel free to do that. It is a may, it's voluntary. I do recommend it. Also, what you can't do, I need to say, you cannot tell an employee to go get a clean bill of health from a doctor. That is put out, I believe, by the CDC because they don't want to overburden the doctors. They don't want to overburden the medical industry in this crisis with employers sending their employees. So do not ask your employees for a clean bill of health. Just ask for whether or not they tested positive or negative. And sure, if you would like to ask for a copy of that, you can do that. I will get into confidentiality on that in a bit. You can also ask require your employees to take their temperature. You can take their temperature. So there are various ways to do this. You could have a thermometer at everyone's desk and require them every day when they sit down to take their temperature. Some businesses are using thermal scanning or infrared, no contact. So you're allowed to do that. And it's not a bad idea because it's good for business. Next thing you know, someone comes in with coronavirus, infects one person, and it just snowballs, and then you lost your workforce. So it's always a good idea to take measures to make sure that it doesn't spread like wildfire in your office. You are allowed, but not required, you're allowed to require remote working from home. That is completely acceptable. I do want to just jump in on that for a second. There are a few cases that I have seen that require employers to reimburse employees for partial use of internet and cell phone if that is being used for work. So do keep that in mind. There are a few cases out there, but I want to bring that to your attention so that you're aware of it in case you wanted to to pay for that. You can require infection control practices. That would be more of like social distancing. That can be washing, disinfecting, Purell, etc. And like I said before, you can require employees to confirm that they're fit to return to work. So let's go to the next slide, please. And please all understand HIPAA requirements. HIPAA regulations are healthcare confidentiality regulations, and you as an employer, if you find that someone has coronavirus or any other medical condition for that matter, you must keep the identity of that person confidential. Don't find yourself in hot water with a HIPAA violation by revealing that to anyone else. Sure, you could say, look, generally speaking, these people in this department need to quarantine because there may have been a possible exposure, or one of our employees. Do not reveal the person's identity or give any other information which makes it obvious who that person is. You must have proper cleaning protocols. You must send home sick or symptomatic employees. And as I mentioned before, inform and send home coworkers of an employee who tested positive to be tested, or as an alternative to be tested, self-quarantine for 14 days. So now that brings us to part 3 of our talk, furlough and termination. So employers, small business owners, should know that in general, employment is employment at will. And in almost every single state except Montana, I believe, it's employment at will, which means you can be fired for any reason, good reason, bad reason, no reason, except where there's an employment contract, an enforceable contract, or the firing is happening because of one of the protected classes, such as race, religion, gender, disability, sexual orientation, national origin, citizenship, or age, or because you complain about one of those protected activities, or you're complaining about any safety issues or illegal activity. Aside from that, if you are firing or laying off a person for any other reason, you don't like the way they tie their shoes, you're allowed to do that. But again, if it's because of one of the protected classes, you can't. So difference between furlough and termination. In my business with the coronavirus, since we had a certain decrease in calls coming in, or we have no need for certain employees at this time, we furloughed certain employees. Furlough means that the employees are temporarily suspended. They are still considered an employee, and that at the end of the coronavirus crisis, they will come back to work. So they're still an employee. And regarding termination, there's nothing. They're done. Expect them to go find another job. If you want to increase the chance that they will be back at the end of this, furlough them. Do not terminate them. Regarding more differences, furloughed employees get to keep all of the benefits during their furlough. So if you, the employer, pay for their health insurance, just because they're on this furlough, you have to continue paying for their insurance. Only if you did that before, of course, or a 401k, or if you pay for a health club membership, whatever the benefits are, you have to keep doing it. Termination, obviously, you don't. So could you fire someone and take them back? Yes, but like I said, you're in much better shape of bringing them back. You have a much better chance that they will come back if you furlough them. with respect to difficulty for employers, furlough's easy, you give them a notice. Termination, while it is typically easy, you just say to them, you're fired, I'm sorry, we had to terminate you due to what's going on. There may be additional paperwork. Perhaps your business requires exit interviews, or if they're applying for unemployment, and you're actually firing them for a significant reason, such as theft or gross insubordination or something. In that case, they would not be entitled to unemployment. You would have to fight it. So that would be the difference between with respect to difficulty. Unemployment, both of them would be entitled to unemployment, and there are incredible opportunities for employees to get a lot of money now on unemployment, which now brings us to the next slide. The CARES Act, furlough and termination, to talk about unemployment and other benefits. So with respect to unemployment, for one of the first times, self-employed people, part-time people who don't have enough hours that they normally would be entitled to unemployment, they are entitled to unemployment benefits. In addition, and this is for all you small business owners out there, if you yourself had to stop business altogether, you as a small business owner can apply for unemployment benefits. This is groundbreaking, and I highly recommend that you do so if you are out of business because of what is going on right now, and do apply. And that takes us to the next great benefit of what's going on, and that is, in addition to your state's unemployment max benefits, let's say it's 500, 550, whatever, the employee is entitled to an additional bonus of $600 per week. So they're making possibly $1,100, $1,200 a week while they're on unemployment and not able to work. This is great for the economy. This is great for your employees, and keeping them happy while they're not working for you. But I have to add, it also provides a little bit of reluctance when you want to bring them back. And I have already experienced that, that when you try and bring your employees back and they're, well, wait a minute, can't I just stay on unemployment for another, until this is over? I'm making so much money on this. So just be aware of that when you try and bring them back. Another part of the CARES Act is all private insurance must cover COVID-19 treatments, tests, and vaccine, regardless of what type of insurance it is. And lastly, I'd like to talk about the Paycheck Protection Program. Now, this is not a seminar on the Paycheck Protection Program, but I will mention it briefly, because if you haven't done so already, run and apply online through your bank for the Paycheck Protection Loan. And this will entitle you to a interest-free loan for 6 months, interest-free, no payments, and then it's a 1% interest rate. And you can have up to 8 weeks of payroll and rent/mortgage interest/utilities forgiven. Free money for struggling businesses during this coronavirus crisis. And they already ran out of money once. They had a new influx of money, and feel free to apply as soon as possible. And I will give you one other tip on that. Feel free to apply through more than one bank. Some banks are excruciatingly slow, and it's not fraud. Whichever, you can only get it once. The first bank to get you the loan will be the one that you get, and you will not get another one. So that takes us to our question and answer section, and I turn it back to Charley or whoever. Thank you.
Hi, I can take it. I've got the questions in front of me here. Derek, thank you so much for the great information. I think the first question would take us back to your topic about paid sick leave. So Monica in Hanover, Pennsylvania asked, my employees are commission based only. How do I determine what their sick paid leave would be? Their working hours vary per day and per week.
Okay, so if they're, a lot of my employees are commission-based also. So if they're commission-based, you take a look back for 6 months, you take the average of what they're making per week, and that becomes their weekly rate. In the event they're working for less than 6 months, you take what you got and you average it. Hope that helps.
Awesome. And then another question that was actually in one of our top topics from our initial survey that people responded to related to workplace policies. So Renee in California asked, what, if any, changes do we need to make to our employee book?
Okay, so it's a great question. And first of all, please make sure that you have an employee handbook. Number one, I can't tell you how many friends of mine, business owners who I deal with, they don't have employee handbooks. They don't have posters up that they're supposed to have up. So you need to have an employee handbook that has at a minimum an anti-discrimination and anti-sexual harassment policy in effect. That not only helps stop discrimination and sexual harassment in your office, but it also can help insulate you from liability should a claim be made. So you need to update to make sure it has that. I'm not, me personally, for myself, for other small businesses, I'm not a big fan of having this voluminous employee handbook that documents every little policy in your company. I like it short and sweet. I like the ability to make changes on the fly. I don't want to be held down to any particular policies and have a handbook shoved in my face. So my advice to you is, at the very minimum, have a policy in effect for anti-discrimination and sexual harassment. And now that we have this new coronavirus crisis law, the First Families Law, until December 31st of this year, make sure that they are all aware of their rights under both parts, the emergency and the Emergency Family Medical Leave Expansion Act.
Alyssa, could I jump in for a second? Expand on that a little bit? Great. So Derek, I just want to say you gave me some new information too. When we're talking about employee handbooks, I want to say that you can get your employee handbook at Rocket Lawyer. If you have a Rocket Lawyer account, it's free with your account, or you can go create one to start for free. So you can get that employee handbook, and attorneys like Derek can help you out with it as well. Second, wow, the poster. So you mentioned that a second ago briefly. I wasn't aware of that myself. So this FFCRA poster, can you tell us a little bit about that?
Sure. So on this is directed to me, correct?
Yeah.
Okay. So on so the Department of Labor has printed a poster that all employers with less than 500 employees must. It's not a suggestion. You can get fined for this. You must post it in a conspicuous location at places of employment. If you have various places of employment, you have to put it in all of those locations. Now that most people are working from home, the Department of Labor has allowed emailing of that. So you must, and I can't stress this enough, notify all of your employees of their rights under this Families First Coronavirus Response Act through this poster. Please send it to everyone so that you're kept out of hot water and your employees know what their rights are.
So I think Alyssa is going to facilitate sending that by email to all of you who are watching as a PDF that then you can send to your employees. You can also, again, go to Rocket Lawyer and download it, but we wanted to make sure that you had that information. Thanks, Derek.
Great call out. Yes, we'll make it easy for everyone. We'll follow up to everyone who's registered for this session with a copy of that PDF. We'll also have a recording of the session. I know of several folks have asked if they could see the materials after the fact, so we'll also send that out. So thank you. So more questions. There's a couple. One of the top topics we had heard in advance was about any requirements for employees when they do return to work. Do we need to provide masks, require that they be worn? Any other accommodations? We had another question come in to ask specifically if there's only 5 people in the office, is it okay not to wear masks? So what are the policies around that?
Okay, well, presently there is no requirement that employers, unless it was already required in certain food establishments, restaurants, what have you, there's no requirement that they have to wear masks. But like I said before, it is a good idea to have them wear masks until we are out of this crisis. Studies have shown that it drastically decreases the distance which a cough will travel. And so again, good for business. You want to keep your work staff healthy so that they can continue working for you. So, but I will, one caveat on that, the law may change because all of the states are working on back to normal, back to work regulations. And so it may in fact be required when quarantine orders are lifted that your employer has to have employees wear masks.
Okay, thank you. Kind of on a related note, so someone asked, when I ask an employee to come back to work, but they're still concerned about the virus, what are my options, especially if I need them on the job?
Okay. I don't mean to be flippant in here, but you can simply say these words, you're fired. And if, the OSHA regulations say that an employee does not have to come into work if there is an imminent, and that's a very key adjective, imminent threat of serious physical bodily harm or death. And the coronavirus, it's just not imminent. It's not imminent now. So they do have to come back to work. They're not allowed to refuse. And you can tell them, but be nice about it, of course, because they're your employees and you want to keep them. But I will make one caveat. Again, in law, everything in law, it depends. So you've got the Americans with Disabilities Act, which says that all people with disabilities are entitled to a reasonable accommodation. And let's take, for example, someone who has a heart condition, cardiovascular condition, diabetes, one of these conditions that makes them particularly susceptible to getting coronavirus. It can be argued, and me, if I were representing them, I would make the argument that they're entitled to a reasonable accommodation and that they don't have to come back to work because they are at such great risk of being hurt, of catching coronavirus and dying. So just be aware that if the person does have those types of conditions and they raise that flag, or even worse, they say, I feel like you're discriminating against me because of my disability, these are little triggers that go off that should make you tread lightly.
Great, thank you. So Monica in Pennsylvania had another question related to paid leave. So she's asking, my company states that full-time is 30 or more hours per week for providing dental and vision benefits. Wage and hour states full-time is actually 40 hours per week. So which would she wants to know which she would go by to determine sick leave pay in that scenario.
Okay, so if I understood you correctly, the employees are working 30 hours a week rather than 40 hours a week. Is that right?
30 hours is what they consider full-time at their company, but
Okay. Okay.
full-time is generally
i-
40.
in that case, it would be a pro rata calculation, and it would definitely be a pro rata because according to the Department of Labor, they are part-time. I also, before you make these calculations, I invite you to go to the Department of Labor website, and they have a full, very easy to understand FAQ section where they tell you
Yep. Did we lose Derek?
exactly. Hello, can you hear me? Hello,
That's better.
can you hear me?
Yep, I can hear.
Okay.
Yep.
All right. That was probably my son online. So,
You're back.
yeah, yes. So I would say that uh, they they would be on a pro rata basis. Go to the Department of Labor website. I've even seen calculators online where you plug in their wages, their hours, and it will give to you exactly how much you're supposed to pay. Department of Labor FAQ website is your friend.
Great. Thank you. Okay, so we have a question from Christina in the Outer Banks of North Carolina, beautiful place. So she's asking, will employers be liable or charged unemployment payments for laying off employees after June 30th? She's saying to fully take advantage of the PPP program, 75% of them have to be used on hiring and payroll within a short duration of time. She's concerned because she has a tourist business and doesn't see enough business to sustain payroll after June 30th.
Okay. So if you are under the PPP, if you are paying your employees and they're at full salary now, and if they are, regardless if you have them working, if you're paying them full salary now, and you keep that ratio that you mentioned of 75 to 25, 75% is going towards payroll, 25% towards other expenses such as mortgage interest, rents, and utilities, then you will get that loan forgiven. The part about June 30th, which you mentioned, that you don't have to restore, you don't have to pay these employees at 100%. You don't have to rehire them right now because you have the opportunity to quote unquote cure that by rehiring everyone and bringing their salary back up to 100% before June 30th. So I hope that helps. But if you're not able to hire them back by June 30th, then you're going to have to maintain that ratio that I mentioned and keep them at their full salary for that period.
Excellent, thank you. So I have one here related to working from home. We have a question, am I responsible for any injuries my employee incurs while they're working from home?
Okay, great question. And in general, you're not responsible for any of your injuries to any of your employees ever. And the reason being is because you should have workers' compensation insurance, and almost all states have a workers' compensation exclusivity bar, which says that the employee's sole remedy when they are injured is not against the employer for negligence, like a tort action, but rather to go through workers' compensation. I do want to mention one little caveat there again, back to the Americans with Disabilities. So let's say you have someone who's on a reasonable disability, reasonable accommodation, and they can't lift over, 50 pounds. And you have them lifting 100 pounds in violation of that reasonable accommodation, and they get injured. In that case, you could be sued for a violation of disability discrimination, ADA, and that would be one of the very few instances where you are liable for their injuries yourself.
Great. Another one that was a big topic that we heard from our first survey was related to, you touched on this a little bit earlier. What are employees' rights in a layoff, and what information do I need to provide?
Okay, so that goes back to employment at will. What are their rights in a layoff? Nothing. You can say you're fired. You can say I'm laying you off. Obviously, be nice, be kind. A lot of employers have a practice of giving a severance agreement, even when they don't have to, so that the employee can receive some money. The employer gets comfort in knowing that they're not going to be sued for discrimination or whatnot. Do keep in mind, however, that sometimes that piques the interest of the employee and says, "Ooh, why am I being asked to sign a severance agreement?" But what are your obligations when laying off someone? Nothing really, except you have to provide them with COBRA notice. If you are providing them with health insurance and you have over 20 employees, you have to give the employee the opportunity to continue with their health insurance. So you as the employer don't have to pay for it anymore if you were, but you have to give the employee the opportunity. Do I have a lost connection? Can you hear me? Can you hear me?
Yep, you're okay. Yep.
Oh, good. Okay. So you have you have to provide your departing employee with a notice that they have an opportunity to continue with their health insurance, that they must pay the premiums every month for up to 18 months. Make sure you do that, because I have seen cases where employees were not given that notice. They lost their health insurance, and they had massive medical bills that they then looked to the employer to pay. So please be careful.
Great advice. And I just say we have time for a few more questions. So if you have anything, please use the QR code. Hopefully we can throw that slide up again, so you can submit any final questions. Charles said anything legal that you had in your mind, he would try to field, even if Derek, as our employment law specialist, can't take that one. So last call there, but we have another one here coming in from Claudia. She's asking, if an employee has a child to care for at home, could I still terminate them first and not pay the family paid leave?
Yes. So wait, if I understood you correctly, because you were breaking in and out, if you, the employer, have an employee who's at home and that employee is pregnant, is that the question?
Caring for a child.
Caring for a child. Okay, so you have an employee who's caring. So the trigger, don't forget the trigger in both of these, the short term and the long term, is that the employee comes to you and says, I can't work. I cannot work because I have to care for my child. But if you fire them for a non-discriminatory reason, before that trigger, before they ask for the leave, they cannot get the leave. They cannot get that. But you also reminded me of something else, that if you are an employer with less than 25 employees, you can be exempt from paying any of your employees if it would cause an undue hardship on you. You wouldn't be able to make expenses. And that's something that you would actually have to show the Department of Labor. But again, you're getting reimbursed. It's good business. It's good for employees. Pay your employees. You're going to get paid back 100% anyway. Just make sure to document why they took the leave.
Great. Okay, so I think we've actually hit on most of the topics that have come through and a lot of the questions. So I guess I would hand it over to Charley if you have any final words for the audience.
Great. Can you hear me, Alyssa?
I can hear you.
Hello, can you hear me?
Yes.
Okay. Well, I want to add, yes, a couple things quickly. So earlier, Derek was talking about work from home policies and what employers might be liable for, injuries, et cetera. It was a great answer from Derek. I was just going to add, along with the employee handbook, a work from home agreement has become very popular. We've seen a 2,000% increase in those contracts. So you can document your work from home arrangement with your employees with what's called either a work from home agreement or a telecommuting agreement. And we have those available for you at Rocket Lawyer as well. And again, I just want to say thank you to Staples for hosting this webinar. It's been terrific. And I want to say thank you to Derek for being so informative and for being so helpful.
Thank you, Charlie. And thank you, Derek, as well. I agree. Really great information. We didn't have your video there, Charlie, but we could hear you loud and clear. So I appreciate that wrap up. Just to close, again, thanks to our speakers from Rocket Lawyer and everybody that watched with us today and for all the great questions. Like I mentioned, we will be following up with a recording of the session. I know a few folks had mentioned some audio issues, so that should be a nice clean recording of everything that we covered today with all the materials, and of course the workplace poster as well. So once again, thanks for your time, and stay well, everyone.